This is the third in a series of short videos that will provide information about the Family Homes on Reserves and Matrimonial Interests or Rights Act, or the Act. This video explains the rights of spouses or common law partners upon breakdown of the relationship, according to the Provisional Federal Rules as outlined in the Act.
The Family Homes on Reserves and Matrimonial Interests or Rights Act has two main parts: a lawmaking mechanism that provides authority to First Nations to develop and enact their own matrimonial real property or MRP law, and a series of Provisional Federal Rules. These are interim rules that apply to spouses and common law partners living on First Nation reserves that have not yet passed their own matrimonial real property or MRP law. These rules are outlined in sections 12 to 52 of the Act. The rights outlined in the Act apply to married couples and common law partners living on reserve where at least one of them is a First Nation member or an Indian. Section 13 provides that each spouse or common law partner has the right to use, possess, and occupy the family home during the conjugal relationship, whether or not that person is a member or an Indian. During the relationship, the family home cannot be sold, disposed of, or encumbered by remortgaging it, for example, without the free, informed, and written consent of the other spouse or common law partner. This also applies whether or not the other spouse or common law partner is a First Nation member or an Indian. When a relationship breaks down, if a couple is unable to resolve their MRP matters amongst themselves, the Provisional Federal Rules allow spouses or common law partners to access the rights and remedies contained in these rules by making an application to the Superior Court of the province in which they reside. Either spouse or common law partner has the right to apply for an exclusive occupation order under Section 20. This would provide for one of the spouses or common law partners to have sole occupancy of the home for a set period of time. It could be for a number of days or a longer period, such as until children reach the age of majority. The order does not involve a change in ownership. The Chief and Council of the First Nation must be provided with a copy of the court application and be given the opportunity to address the courts regarding cultural, social, and legal context that pertains to the application, and to present its views about whether or not the order should be made. The views of Chief and Council will be taken into consideration, but may not determine the eventual decision of the court. The Act also contains provisions for addressing family violence. Section 16 of the Act provides that either spouse or common law partner can ask the courts for exclusive occupation on an emergency basis. This is known as an Emergency Protection Order, or EPO. An EPO can provide immediate protection for families by removing an abuser from the home for up to 90 days. However, the Act provides for the Lieutenant Governor and Council of the province to designate judges for the purposes of issuing emergency protection orders under this Act. Many provinces have not yet designated judges for this purpose. Without designated judges, emergency protection orders under Section 16 may not be available in your province. In addition, when a conjugal relationship breaks down, or in the event of the death of a spouse or common law partner, the Act identifies a process and methodology for determining the valuation of the matrimonial real property and how those interests or rights are divided. Video number 5 of this series presents further details about this subject.
For further information, please visit our website at COEMRP.ca. This video is for information only and should not be relied upon as legal advice. Individuals should always obtain legal advice from a lawyer familiar with their specific circumstances and the provisions of this Act.